Okay, well, welcome everyone. Appreciate you attending our program today, avoiding regulatory trouble and responding to government inquiries. This will be an anti-fraud update for FDA regulated manufacturers, so drug and device companies. Again, thank you for participating. We will be recording this session, so the slides will be available. If there's anything you'd like to follow up on today, please feel free to reach out to myself, Dulce, or Amanda Johnston. This program was hatched by Dulce and I last summer on a patio on Lake Minnetonka. A little bit different than today. We have a kind of a gray day here in Minnesota, but we wish we were all in person, perhaps down at Fredrikson Byron, in Minneapolis, but we're virtual, which is fine. But yeah, we certainly miss seeing all of you in person. But hopefully the next program maybe we'll do one in the spring. I know that Gardner Law is currently looking at a program in Utah again, perhaps at Snowbird. So hopefully we can get back together in person soon. To give just a quick overview of the program today, if you want to go to the next slide. Here's our agenda. So we will discuss, Dulce and I will discuss recent FDA, AKS, and FCA cases. And sorry for all the acronyms. We'll try and spell things out for you as we go along. I think everyone knows what FDA means. Anti-Kickback Statute is AKS, and FCA is False Claims Act. So Dulce and I will cover those cases. We'll then turn it over to two speakers, one from drug, one from device, Brent and Sarah. They run respectively legal and compliance in their companies, and give their reaction to these recent cases and the OIG Fraud Alert guidance, which Dulce and I will also cover. We'll have a short break. Please feel free to come in and out as you wish throughout the day, schedule permitting. We'll then have Amanda Johnston talk about deploying a compliance program, performing investigations. Sandra Cito will discuss managing compliance, kind of a day in the life, if you will, of Chief Compliance Officer. We'll have another quick break. Then Dulce will cover responding to a government investigation, so that white collar perspective. And then we'll wrap things up with a discussion with Ann Miller from Medtronic. Amanda will be asking her some questions on recent FDA enforcement. So I'll hand it over to Mary Heath. She will be our moderator throughout the day. She's an attorney at Fredrikson Byron in the health law practice, where she focuses on health law and has various industry clients, including pharmacies, manufacturers, others as well. Mary, I'll hand it over to you.
Thanks, Mark. All right, before we dive into the content today, I get the privilege of going over housekeeping items. So if you're unable to stick with us for the full program, it's not a problem. We're recording, and you'll receive an email once that recording is available. For those of you who are interested in continuing education credits, this webinar has been approved for 3.5 standard CLE credits in the state of Minnesota. And people attending live, so not those watching on the recording, will receive an email with the CE details in the next couple of days. So as time allows, as we go through the sessions, we are going to incorporate Q&As at the end of each session. So we won't be interrupting the speakers, just an FYI. If you'd like to submit the questions, send them through the Q&A function that's at the bottom of your screen. You can also use that if you have any technological issues and you need to reach out and let us know. All right, so with that, I'm going to move on to our first session. Recent FDA, AKS, and FCA cases led by Mark Gardner and Dulce Foster. So Mark, who we just heard from, is the directing attorney at Gardner Law and has spent the last 22 years working in the healthcare industry, advising companies on topics like healthcare compliance, advertising and promotion review, FDA regulatory, quality, and clinical matters, and a whole slew of more. He's an adjunct professor of law at Mitchell-Hamlin School of Law, where he teaches drug and device law. And he's also on the Mitchell-Hamlin School of Law Health Law Institute Advisory Board, which I did practicing in the mirror a few times. Dulce is a shareholder at Fredrikson Byron, where she's the co-chair of the White Collar and Regulatory Defense Group. She has spent 21 years in FCA and healthcare fraud litigation, focusing on criminal and civil regulatory matters involving alleged financial fraud, embezzlement, healthcare fraud, FCA violations, FCPA violations, trade secrets theft, and other compliance concerns. She was also a former clerk to Chief Judge John R. Thunheim. So Mark and Dulce, I'll turn things over to you.
Thank you very much. We can go to the next slide. So Dulce and I will just, we'll be covering a bunch of cases. We tried to curate some cases that are relevant and span anti-fraud, False Claims Act. We'll talk about these laws a little bit more as we describe the cases. The Sunshine Act, which I think everyone's familiar with, and the Food, Drug, and Cosmetic Act. And then we'll talk about the OIG Speaker Fraud Alert. Dulce, if you want to say hi to the folks and anything
Good morning.
Yeah. So we'll be kind of just going over these cases together. So Dulce, as we talked about, please interrupt me. I'll take a laboring oar on kind of briefing these cases, if you will, as we talked about, and please jump in anytime you like.
I will do that. Thank you, Mark.
Great. All right, next slide. So these are the trends. Literally we could have had one slide today and talked about the topics on here for the next, 50 minutes that we have until we turn things over to Sarah and Brent. But, this is an important slide for everyone just to get a sense of what's going on out there. We appreciate that you're all very busy and it's hard to keep up on all the cases, the government guidance, things that are coming at you. But these are 2021 trends. I think Dulce would agree with me that, we expect these trends to continue. So the types of cases that should be on your radar: anti-kickback relating to bribery, the False Claims Act cases. If you violate the AKS, you're violating the FCA. The White House is sent a signal, hey, we're prosecuting what we see as fraud and abuse, spanning all industries, but healthcare has always been a focus, of course. Just the sheer amount of dollars at stake in the federal budget related to healthcare is huge. So they will continue to focus on that. The Trump administration focused on that, and the Obama administration before it. FDA cases, we'll kind of unpack that for you a bit. Sunshine and privacy. These are the trends. These are where the cases are. You can see under anti-kickback, we have a bunch of sub bullets there. Free marketing programs, always something to be mindful of, your sales and marketing folks, and transfers of value that could be construed as bribes, getting to practitioners to induce purchases. And we have a litany of other things there under the anti-kickback, which you can take a look at. The FDA theory is newer. The first case that we're going to talk about in a minute is an FDA case, and we'll dive into that. Dulce, I'll just kind of pause for a moment. Anything you'd like to add here?
I'm not at that point. I'd like to just dive into the cases and talk about them. I think we've got a limited amount of time here, and it'd be nice to cover as much as we can.
Sounds great. Let's jump into the first case here. Next slide, please. So this is the Alere case. This is an FDA related case. Just to kind of construe the basics of the theory here, the government's approach to this case is they're alleging that Alere manufactured this in ratio product, which is designed to determine how fast your blood is coagulating. They said that they knew that it was being manufactured with some issues from July 19, 2008 through July of 2016. So for, quite a span there of 8 years. And they ultimately didn't address the issues and didn't tell users that the product had an issue with a defect that could impact its ability to do its job. And so the government, is at the end of the transaction paying for the devices and says, hey, we're not supposed to be paying for these things when you knew they were defective and we are ultimately harmed here. And your failure to do a recall, to correct the issue, and to ultimately make a business decision, as you can see in a sub-bullet here, we take issue with that, and we are going to punish you. So this ended in a nearly $39 million False Claims Act settlement. Again, FDCA, Food, Drug, and Cosmetic Act violated, and purchases were induced by the company, their sales, whatnot, without notifying the government that there was an issue with the product. And so the government ultimately took issue with this. Dulce, do you want to say a few words just about the FCA and the construction here?
Yeah, so I think that what's interesting about the Alere case and this, what I think are seeing as a growing trend in some of these quality cases being brought is that, historically, at least, over the past 10 years or so, there's been a lot more FDA off-label enforcement along with the Anti-Kickback Statute, which is really kind of a contorted legal theory that the government's bringing, because doctors, as we all know, can legally prescribe off-label unless there's a national coverage decision or some other local coverage decision or some other guidance that says otherwise. Off-label prescription and Medicare coverage for those prescriptions is authorized. As we've got some recent Ninth Circuit decisions confirming that the off-label status of the usage of a device or a drug doesn't dictate whether or not there's Medicare coverage for it. And so to bring a False Claims Act case based on the off-label usage of it, it has to be joined up with an anti-kickback case or something to try to show that there is some sort of fraud on the federal fisc, that the federal monies were paid when they shouldn't have been. And so ultimately, I think the traditional kind of off-label False Claims Act cases that we've seen have been a conflation with anti-kickback cases, where the whistleblowers of the government has alleged that companies pay kickbacks to promote off-label uses, and then the FCA liability derives from that. Here we're seeing a trend, I think, of more cases being brought based on defective products. And that to me is much more, it actually makes more intuitive sense that defective products would be at issue, because that's kind of the traditional, that's what the FCA was grounded in. This was a statute that originated during the Civil War, when suppliers were supplying defective military equipment to the soldiers in the war. And the government decided to enact the False Claims Act to combat the use of or the selling of defective products to the government. And so these quality-based False Claims Act cases really, to me, feel like the government's kind of going back to its roots. It's a more direct and simple theory of liability that if you recklessly supply defective goods and the government pays for them, then that's a false claim.
Yeah, thank you. Yeah, I'd also point out, the fines for violating the False Claims Act, 11,000, and this is, Dulce, I know this is something by heart, given your practice, $11,000 per false claim, plus 3 times the amount of damages sustained by the federal government. I imagine that those fines rack up very quickly. In a case like this, where they're coming up with this $38.75 million, just a quick question, Dulce, here. Did they ultimately go through and try and track how many violations occurred, or did they just kind of get a ballpark? We've of course seen some of these cases go into the billions of dollars. I'm just kind of curious your thoughts there.
Like how the damages get calculated?
Yes. Mm-hmm.
So there are multiple ways that the government can go about slicing that apple. Sometimes they'll look at the amount of profits that a company has garnered. And that is, in fact, the basis for if there's a criminal case that arises for healthcare fraud, what they're looking at is in fact, going beyond the statutory criminal limits, but to the amount of gain, and then trebling that. In the False Claims Act context, what they will do is they will typically look at, instead of on a per claim basis, they will treble the damages. So they'll look at what the government paid. And there's some dispute that arises in some cases about whether it's, is it the total amount that the government paid for the product? Or they actually did get some product out of it? Or is it just the amount that they paid more than they would have? In the anti-kickback context, it's pretty much the theory that's been accepted that the whole transaction is tainted. And so the damages are derived from the total amount that was paid for the product. And then depending on the amount of culpability that the government wants to assign to that, it can be up to treble that amount. There is this $11,000 per claim is kind of an alternative basis for calculating the amount of the penalties that will be paid. But frankly, what I've seen much more often is just this global look at what was the total amount paid and then a trebling of that, or in cases that are settled, sometimes maybe a doubling of that.
Okay, thank you. Just a couple of comments before we go to the next case here. I note that Abbott bought this company in 2017. Is kind of interesting. I wonder if they knew about this quality issue and just kind of factored that in. I know that we work with buyers and sellers on diligence a lot. Our practice is really transactionally focused, not litigation, like Dulce's practice. But these, I'm kind of curious if Abbott ultimately had some idea about this issue. But at any rate, the last thing I kind of want to leave with the audience here, because we do, our team consists of people that worked at companies like Medtronic and Abbott, for that matter, and others, and their quality and regulatory folks that are attorneys. So we deal with these questions a lot, like, do we have to do a recall? Can we close out this CAPA, et cetera? So here, just in the sub bullets, Alere received repeated warnings, including, and this is from the settlement agreement. They received multiple warnings, including from their own personnel, that InRatio's algorithm was flawed and could return discrepant results. In this next bullet, rather than pursue, and again, the government, I really think Dulce probably is writing this or dictating a lot of this language in settlement agreements. So perhaps we're not getting Alere's side of the story here as much, but I suspect rather than pursue further work to fix the problem, Alere acknowledged internally to make a, quote, business decision to close their CAPA, their corrective and preventative action investigation, without fixing the InRatio algorithm defect. So, we're a part of these business decisions. It's just, I think the trend here is to be really careful when looking at these quality issues, because they could have long-reaching impact. Here it's the settlement agreement also says that the product was linked to over a dozen deaths and 100 injuries. So just to be very careful with those decisions is my parting comment on this case. We can go to the next slide. Another FDA case. This one involves St. Jude and their ICDs and CRTDs. Hopefully the audience kind of appreciates what these products do, but they're used in the heart, and they're intended, for example, to detect and convert potentially fatal heart arrhythmias by delivering electronic shock to the heart. This technology has been around for some time. So we have a couple years here, 2014 to 2016. You'll notice a lot of these cases are, they're not like from this year. It's because it takes a long time for these cases to be litigated or settled. But with this one, it's a similar theory. The government saying you violated the False Claims Act because you knew of a defect, you didn't fix it, you should have told us, and we ended up paying for these products. In this case, the government contended specifically the following statement to the FDA was false and misleading. Again, this is from the pleadings in the case, actually the settlement agreement, by recollection. No serious injury, permanent harm, or deaths have been reported associated with this complaint. So that was the complaint that was filed to the FDA. The government took issue with that, because at the time they said there were actually 2 injuries and a death, and they should have corrected that statement. How did this case come to light? A patient who was implanted with the device 15 days after she was implanted the company issued a class 1 recall, which is the most serious type of recall, which, was class 1 is for devices where serious or adverse health consequences, including death, could occur. And she was upset. She had this device implanted and then later learned that she had to have it explanted, or was told that the device, the battery may die with no warning. So she filed the KETAM case, a complaint, which maybe Dulce, if you don't mind, explain what the whistleblower provision, the KETAM provision, the False Claims Act, quick to the audience. That would be great.
Yeah, sure. For folks, I imagine a lot of folks, probably who are attending have already familiar with this, but for those who are not, the False Claims Act has two different pathways that can result in a case. One is the government just brings a direct claim and based on information that they have that they believe they've been defrauded, and they file a case. The other route, and the more common route, is through whistleblower claims, and this is when a disgruntled employee or a competitor or who knows, somebody who decides they might have that the government might have been defrauded, will bring a claim forward on behalf of the federal government. And so they file a lawsuit. It's kept under seal for a period of time. The government will then evaluate. So one of the obligations that the KETAM whistleblower, or they're called relators. So one of the obligations that the relator has is to bring forward all of the evidence and information that they believe supports their claim to the assistant U.S. attorney who's reviewing it. So they bring that to the table, it gets reviewed, and then there's an investigation that the government engages in to evaluate the claims. And then at some point, the government will issue what's called an intervention decision. And we'll make a decision, are we going to take over the case or not? And if the government intervenes, then the government really drives the case forward. If the government does not intervene, then the whistleblower has a choice of either dismissing the case or proceeding with the case, and bringing the case, continuing to bring the case forward, but with the whistleblower's counsel. In either case, the whistleblower can take 25 to 30% of the proceeds, and then the rest goes to the United States.
Yeah, wow. So quite an incentive for the whistleblower there. And we'll talk about a case in a minute where the whistleblower received quite a large sum. So just a couple more comments on this case, and we'll go to the next one. The initial, some of you may be thinking, how did this happen? I think St. Jude initially considered the risk to be small and later determined it to be larger. And this is from the Star Tribune. St. Jude acknowledges that it continued to ship its stock of the old devices for 17 months after making a design improvement that reduced the potential for the device to lose power unexpectedly. Unfortunately, there were 2 confirmed cases of patients dying after the battery problem caused the device not to administer the shock. So again, yep.
Okay. I'm sorry, Mark. So what I was going to say, what I think is an interesting sort of thought exercise is to compare this case to the Gardner case that happened, I believe, was it maybe 11 years ago now, 2010. There was this big criminal case that was brought against Gardner. And I think there's some striking similarities to the fact pattern. Both of these cases involved ICDs with battery failures caused by short circuiting that resulted in patient deaths. Both cases involved multiple models of the devices that the companies manufactured. Both cases alleged that the companies downplayed the significance of the defects when they talked to the FDA about it and said that they hadn't resulted in serious harm to patients when in fact patients had been harmed. And it's striking to me that, the Gardner case was a $260 million criminal fine. And this case was, a much smaller False Claims Act penalty. And other than the sort of the general scope of the damages, what tripped this from, or the Gardner case from a False Claims Act case to a criminal case, and why was this, treated a little bit less harshly? And the only difference that I can identify, and maybe there are other commentators out there with different views, is that one of the things that Gardner did was issue a silent recall. And so they they actually very clearly were aware of the fact that there was a problem going on long after they had made their report to the FDA, and they sent these sort of emergency notifications out to doctors in the form of a product update, which really, kind of, I think, angered the FDA. And I'm wondering, or, speculating, I guess, that maybe it's the failure to report to the FDA when it became really, really clear that they knew that there was a problem that may have pushed it from being just treated as a kind of a more run-of-the-mill False Claims Act case and into the criminal territory.
Yeah, no, that makes sense. A transparency issue.
Yeah.
All right, let's go to the next slide. There are more FDA cases out there. We're just kind of, again, giving you a sampling here. Let's kind of shift gears and get into more anti-fraud. So this is Medicrea case. This is a French company. Ultimately, the allegations involve bribing this French company bribing doctors, American doctors, and ultimately not reporting the payments for the Sunshine Act, for example. So this resulted in AKS FCA, a settlement for $1 million there, and also $1 million to resolve the Sunshine Act violations. We're starting to see more Sunshine Act cases. This was interesting. This is one of several that have occurred in the last year, related Sunshine Act cases, that is. So the Sunshine Act was really unenforced for from 2013 to 2020, and now it's I think it's here to stay. Any settlement that comes out is related to bribery, unless the bribes were reported, which is unlikely. Then we're going to see a Sunshine Act settlement or fine. So a little bit on the details here. This involved a whistleblower who is the chief training officer for the company. So again, this is that key tam type of case that Dulce talked about earlier. This employee, felt like the concerns raised were not addressed. And so ultimately the employee said, well, I'm going to make a complaint here. I thought, just kind of interesting, the states getting involved. There's 30 state plaintiffs as well who had False Claims Act statutes that also had key tam laws. So just think about, that even if there's not federal reimbursement, sometimes in cases, and in this case there may be state laws that protect private payers, and their statutes are broader than the federal government in terms of not limiting the potential claims to just federal payers. It can cover Aetna, United Health Group, and so on and so forth. We're not going to make y'all anti-fraud lawyers today, but just something to think about. Exclusions mandatory in criminal offenses, for example, Medicare fraud, permissive for civil claims with kickbacks and false claims. So these cases we're talking about are civil, but exclusion from industry is a specter for executives and companies involved in these.
We call it the corporate death penalty in my practice.
Yeah. Why is that?
Because many manufacturers can't stay in business if they can't sell to hospitals that are taking payments from Medicare. Yeah.
I think I heard once that it was over 99% of healthcare, clinic, hospital, et cetera, accepts federal payment on one level or another. So like you said, it's the death sentence. If you get excluded, you're done. You can't sell product to anyone accepting federal dollars. AKS, $25,000 fine per kickback, jail up to 5 years. And as we mentioned earlier, if the AKS is violated, then False Claims Act is violated. And that was, I want to say, that was part of the Affordable Care Act, wasn't it, Dulce, when it was amended? I believe
it was treated as part of the False Claims Act before then. It became more explicit at that time, but there were already, before the Affordable Care Act, there were prosecutions under the Anti-Kickback Statute through the False Claims Act, or not prosecutions, but civil cases that were being brought. So there had been some challenges to whether or not that was an appropriate mechanism to bring anti-kickback cases, and so there it was made more explicit at that time. But I would say that it's been that way for well before the Affordable Care Act enactment. Yeah,
that makes sense. Yeah, implied certification theory, and now it's explicit, which makes the government's job easier. So know that if you are accused of a kickback, that the False Claims Act is going to be in play, and you'll largely see these cases described as False Claims Act cases. For that reason, you may be thinking, hey, didn't this involve kickbacks? I don't really think this was reimbursement advice, for example, wasn't an issue. Well, it's because of the kickback just taints the overall transaction. Then the government at the end paying the bill is saying, we're not paying for things where there's a kickback involved, and we're not paying for things if the device is defective under the FDA cases we just chatted about. This case and the others we'll talk about, there's just something going on in terms of bribery, again, that's tainting the transaction. These complaints you can find online generally. If anyone wants them, send me an email and I'll send them to you in case you're suffering from insomnia some night. You can get into some of these cases. Some of them the complaints are quite long. But here the government said that these are quotes from the complaint. I'll just highlight a couple. Medicare knowingly provides kickbacks in the form of financial incentives, discounts, and other inducements to healthcare providers to gain their business in contravention of federal law. Some of the facts involved family and friends being provided entertainment, meals, the company taking people to sporting events, entertainment. One of the key claims was that the U.S. physicians were taken to France for a meeting and all expense paid, and the government construed those payments as kickbacks, and they were not reported. The Sunshine Act. So just a reminder to everybody, if you have a physician that is a U.S. licensed physician and they're going to name the country, those payments are still in bounds. Just because they're outside the U.S. doesn't mean you get a pass on reporting them. One thing that I kind of found interesting in the case, they talked about tying, giving a discount on one product to induce the purchase of another. Sometimes with these complaints, you have to kind of look a little deeper or even be skeptical in terms of how you view them. There are ways to provide bundled discounts, which are perfectly lawful under the discount safe harbor. Of course, the government wasn't about to write in their complaint in a way to try and defend the practice. And obviously, we don't know whether those transactions met the safe harbor or not. They also talked about free evaluation units. AdvaMed contemplates that for device makers. Of course, drug makers provide samples. There was talk about free tech support in the device industry. It's very common for manufacturers to do things like cover cases and provide information on their products. So again, you have to kind of dig a little bit deeper. This settlement overall wasn't as large as some of the others. Maybe, I'm not sure, maybe that's a reflection of the strength of the case. One other just parting thought here I'll make is that this chief training officer, the whistleblower, pointed out that there was poor oversight of compliance. And Amanda and Sandra are going to talk more about compliance later today, but the CEO ran compliance and HR. The government said that was a conflict of interest. They also pointed out that the sales group ran copy review and was reviewing and approving its own materials. So Fox guarding the hen house there. Let's go to the next slide.
Oh, before we move,
sure.
I had just one more comment about the Medicare case, which is just sort of giving you my white collar defense attorney perspective on reading this, and that is that I think this is a whistleblower. It was brought initially as a whistleblower case, and I see multiple different allegations here. I mean, there's sort of a whole bunch of different directions that this goes in. There's even talk of off-label, and there's the technical support issue and the discounts issue and the tying issue. All of these different issues get brought And when I see a complaint or a case that involves that many different issues, I automatically think that has to be a whistleblower claim. Because one of the biggest differences I see between cases initiated by the DOJ and cases initiated by whistleblowers is that whistleblowers will throw in the kitchen sink. They just look at everything they can think of, they put it in their complaint, and they want to see what's going to stick. Whereas when the DOJ brings a direct False Claims Act case, what you typically see is that it gets derived from an audit or an analysis of claims data, or maybe they're doing an industry sweep, but usually there's, not more than one or two main legal theories driving the case, which in some ways I think those cases are more difficult, because when the DOJ is really driving something, you know that you've got some trouble, as opposed to when a whistleblower is bringing it. But the whistleblower claims can actually be much more difficult to deal with from a discovery perspective, and from it's like playing whack-a-mole, because there's so many different theories that they will hurl at you, and it can create a moving target that's difficult to deal with. So just my thoughts on what I saw when I saw the complaint in this case is clear whistleblower kind of approach.
Yeah, that makes sense, that whack-a-mole, because you have to respond to all the allegations, and if there's dozens, that takes a lot of time.
Yeah.
Let's go to the next slide here. So Merit Medical, I want to say that this complaint was something like 150 pages long, if I remember. It was
closer to 200.
200. So
the initial complaint was, right. Yeah.
Quite a bit. I think this is your kitchen sink type case, if I'm not mistaken. So here we have another whistleblower, Charles Wolf, MD. He was the chief compliance officer for the company. So something to think about. Again, Dulce and I both work with executives, CEOs, all sorts of executives running these companies. You got to remember the whistleblower is probably coming from within more often than not. So all the dirty laundry is right in front of them. So you want to, if you find an issue, you want to address it. This chief compliance officer ultimately took issue with a lot. You can see here from the sub-bullets, arguably the allegations from the complaint was the company provided free services to customers disguised as education. I think that, there's a way to provide education. There's a way to advertise your product collaboratively with customers. There's, AdvaMed has, for example, some guidance around that. It's more common to work with customers on co-promotion in the device industry, certainly. So this boiled down to a local advertising program. They called it LAP. It did not discuss Merit's products. It really was focusing on procedural awareness, but the government ultimately took issue with how the LAP program was designed. I think that, they probably ultimately felt that there was an equitable distribution of costs between the beneficiary, who was the customer, and Merit. The training, this is a quote, supposedly this is said in training, this is off-label, but as long as you are fine talking about it, I'm fine continuing. So this was someone that performing training for staff, for salespeople, telling them how to promote off-label. So if that, assuming these things are all factual, which I believe they probably are since they're in the complaint, that's obviously an issue. You can't train your staff how to promote off-label. There's also a claim that they were promoting an IDE device, an investigational device. You can't promote an investigational device while it's being researched by the FDA. Any other comments on this case, Dulce, before we go to the next one? I know we have
So I actually I had an opportunity to work on an aspect of this case, although I did not represent Merit Medical. So I have a kind of a different perspective, as you might imagine, from what's set forth in the complaint. It's a one-sided view of things that I think gets presented there. Many whistleblower complaints, this was not entirely consistent with my understanding of the facts. one of the key allegations, and I think the thing that really drove the case, was this allegation about the LAP, or the local advertising program, which involved radio spots that featured doctors that did this procedure, and the product that was being sold was a device called Embosphere, which was sort of an embolization beads that were used to treat uterine fibroids through embolization. And this product is something that is administered by interventional radiologists through minimally invasive surgical procedure. But the patients are really coming not from, most patients don't know who, if you asked anybody on the street, who's your interventional radiologist, they wouldn't be able to answer that question. The patients who get diagnosed with these fibroids are being treated by gynecologists who don't do the procedure. And so the company was really looking at doing a direct to consumer ad campaign simply to make the public aware of the fact that there's this other procedure that exists, as opposed to a much more invasive procedure that gynecologists do, that there's actually a less invasive procedure that could be done by interventional radiologists, that the information might not be getting to the patients because of who their direct contacts are with the gynecologists. And so they launched this campaign, and their device was either had the majority of the market share or all of the market share, a significant amount of the market share. And I think the company's thought was, if we do this ad campaign where we educate patients about the existence of this alternative to what they're being told about by their own doctors, then the patients would come into their appointment with the gynecologist and ask about it. And so the goal was to really make them aware that the procedure exists, and also let them know, Dr. Smith in your locality does this procedure. So they would know, not only that they could get the procedure, that would be less traumatic than the other existing, alternative surgery, and who the doctor is that does it. So these ads were done without reference to the product or the device, but it wasn't, the company wasn't doing it to sort of just benefit the doctor, even though it didn't mention the company name. And if you look at the AdvaMed co-marketing guidance, it will say that the materials should be balanced and promote both the company's technology and the healthcare provider's services. But because these ads didn't directly talk about the company, the government took the view that even though they were splitting the cost of the ads with healthcare providers, that this was a kickback because of the fact that it didn't mention the company's product. And I guess I take issue with that, because there's this nuance that just promoting the procedure and identifying where patients could go to get it done was a benefit to the company. And so I think there was this significant nuance that was missed by the government, and that can happen. A well-intentioned promotional campaign could be taken the wrong way by the DOJ, and they will often put on blinders and take the most jaded view possible of what a company's doing. The other point I wanted to make about this case is that the two lead government lawyers on the case were Andrew Caffrey and Christopher Terranova. And the reason I bring these names up is because this is out of at the time that the Merritt case was going on, out of New Jersey. This has been a very active district in bringing these False Claims Act cases forward. Andrew Caffrey was also involved in the Pasira case. Christopher Terranova was also involved in the Alere case. And so some of the same names keep popping up. And if you happen to see those names on a complaint, just recognize that these guys have a lot of experience and really are focused on bringing these kinds of claims.
That's a great point. Great point. Thank you for that. A couple other parting comments on this. I'll just say I don't think Amanda will probably be recommending, or Sandra, a chili pepper scale for compliance issues. One being the least amount of heartburn, and 3 being so. Just, I think the comment there I have is just think about how things that you maybe think are fun or cute might be viewed by others later. Anyways, we can head to the next slide. We could talk about Novartis for an hour, but I will summarize this just so we can get on with a few other comments before we hand things over to Brent, Sarah. This was a big case though, $642 million settlement, 51 million went to copay foundation related issues, and $591 million for speaker program issues. What's interesting is Novartis was in a CIA back in 2010, and I think the government maybe throttled them here a bit because they feel like they didn't learn the first time. This case involved a whistleblower. This rep is, I couldn't find the end amount that this individual received, the former sales rep, again, a whistleblower, but Fierce Pharma reported $109.4 million. And that person wore a wire to try and record, what were viewed as bribes in the process of being provided and accepted. So quite a payout for the whistleblower here. The foundation issue, again, I'm not going to read the whole slide here. If y'all have questions, you can follow up with us after the program. But the foundation issue really revolves around the government taking the stance that drug companies, mainly device companies, don't use foundations as often, but they say the physician comes across a patient, they can't cover the copay, they don't have the resources to basically get the drug. So that patient gets sent to a foundation. The foundation has charitable, means and policies. So they provide access to the drug by supporting the patient financially, and then the doctor's happy because patients gain the drug, and the drug companies ultimately happy because patients are getting access to the drug, and it creates kind of an easier process for just accessing the drug. And the issue the government has with these foundations is that they think that they're just an extension of the drug company, and that the drug company is, telling the foundations what to do. There are a bunch of advisory opinions on point. There's a lot of guidance from government. Some of the advisory opinions have been withdrawn. So you want to be careful if you are running a foundation with how you support that. I should say, you're not running the foundation. How do you support a foundation? Someone else needs to be running it. The other big issue in the case was just speaker programs. And I think this case, more than any others, really drove the fraud alert, which we'll talk about next in a moment here. But, some of the issues that came up here was the government said the speaker program is bogus, quote, little or nothing more than social occasions for the doctors. They took issue with the same attendees at the same programs, which they already attended. They took issue with speakers being paid to deliver a speaker program to one individual, or even still be paid when they didn't do any work. And they also took issue with meal limits being exceeded. There's just a lot of hair on this case. Again, you can take a look at the pleadings in this case, but this really, to me, drove the speaker program fraud alert, which again, we'll talk about in a minute. The restrictions, kind of the aftermath, Novartis is now restricted to paying speakers $10,000 per speaker, max fees $100,000 per year, which is quite low considering how much money they were spending before. The sales function cannot select speakers. Their events have to be virtual, and they can only talk about the drugs for 18 months after FDA approval. And if anyone wants an internal talk, they can't hire a speaker to do that. They need to take someone from their staff. Anything you want to add to this one, Dulce, before we move on?
Yeah, no, just, and we'll get to this, I think, when we start talking about the update, but they really came down with that corporate integrity agreement hard on Novartis about the speaker program. We know that this alert was out there, but the position that the government seems to be going to, which is, oh, well, you survived COVID with virtual events, so therefore everything needs to be virtual from now on. And that's kind of the limit that they imposed on Novartis. And also, by the way, if you're product has been on the market for the 18 months or more, you don't need to do any more speaking engagements. Everybody knows about it. I think these limits are kind of severe, and it just provides a bit of a roadmap into where the government is going with these kinds of things.
Yeah, absolutely. Okay, let's head to the next slide. These next cases I'll kind of cover quickly. Please jump in, Dulce, if you have anything to add. But another whistleblower complaint, this was brought by a pharmacist. So again, the prescribers, or in this case, pharmacists, may be involved in a key TAM case. So you want to be mindful of that. This really revolved around research grants, and the whistleblower took the position that they were bogus, and the government, which picked up the case. Quote, little or no documented description of the proposed research, and Pacira also did not document a reasonable commercial need or a fair market value assessment for the grants. So point on this case, government still clearly has grants within its radar. You want to make sure you have a robust grant making function at your company. And yeah, just, you know, all grants obviously should be for bona fide reason, paid at fair market value. There should be milestones. You should make sure the work is being performed, et cetera.
Yeah, I think the point here is that the need to just be scrupulous about your documentation. You know, a lot of companies do this and then they don't document it well. Be sure to get the documents in the file showing that, you know, you had a need for the work, but there was a fair market value analysis done for the amount that was paid, and then there's documentation at the tail end proving that the work was actually done as expected. So.
Yeah. Let's go to the next slide. So Dulce, this involved another whistleblower, so sales team employee who later claimed a retaliatory termination as well, involved a drug that treated actinic keratosis on the face, and ultimately the government alleged that company was promoting off-label. So we often have said, hey, these off-label cases are kind of dead. But again, this were a whistleblower complaint. I think, you know, again, it's the kitchen sink kind of being thrown in with everything, but we're seeing a lot of off-label allegations coming up in these complaints. The government alleged that the company was promoting the product with a blue light, which was intended to be an activator, and it wasn't approved for that use. They also took issue with free products being billed to samples, being billed to Medicare, used as discounts, and then ultimately not reporting these transactions under the Sunshine Act. So it kind of more of the same, I'd say. This went a little bit, how to juxtapose this against the others, is involved in adjunctive use that wasn't approved by FDA. So be mindful of that.
I mean, I think this is just an example of what I was talking about before, of, you know, the sort of the False Claims Act being used as a tool to address off-label issues, and the need to, you know, for these complaints to also include some sort of anti-kickback component for them to be able to bring that legal theory forward.
Yeah. Let's go to the next slide. Yeah, we won't talk about privacy today, but that's the next kind of storm cloud on the horizon. I hate to sound negative, but the industry does so much good. But we do see privacy becoming a bogey for everyone. So something to think about. You know, regulators throughout the world are ramping up. Amazon fined almost $1 billion in Europe for GDPR violations, and we have new privacy laws popping up throughout the country. So expect federal legislation in the future. Yeah, it'll be, so you're going to want to stay on top of your privacy compliance, bottom line. Let's go to the next slide. We're going to talk for a few minutes about the OIG Fraud Alert. I think everyone's pretty familiar with the Fraud Alert. It's really the government, again, looking at programs, looking at some of what the violations they saw in Novartis in that case, and trying to get a handle on that. Let's go to the next slide. This was just issued less than a year ago, by the way. Greg Dembski, OIG Chief Counsel, told the Law 360, great publication, if you don't subscribe to it, interview that drug makers, and they should they could just put device makers in there as well. Should think carefully about the risks of speaker programs, and in particular, in-person speaker programs. As Dulce mentioned earlier, they're really going after this in-speaker angle, given that the pandemic has demonstrated that high-quality events can be held virtually. So we're, what does the government expect? That they expect you to hold programs virtually now, which, raises questions of First Amendment, chilling free speech, et cetera. But that's what they want. Let's go to the next slide. Frankly, I think, we're seeing manufacturers, they like, a lot of them like the virtual setup. I know Sarah is going to chat about that a little bit in a minute. But so it might just naturally kind of head that way. Here's a little bit more just to jump on that. Risk, and I'll cover this slide pretty quickly, but bottom bullet there, risks associated with speaker programs will continue or will become more pronounced if companies resume in-person speaker programs or increase speaker program related remuneration to HCPs. Let's go to the next. Yeah,
I was just going to say, I worry that what this does is cut out some of the benefit of the in-person programs, particularly where there's demonstrative. On the pharma space, maybe not so much, but in the device space, where you're actually wanting to get your hands on the device, look at it, see how it works. This seems problematic to me.
That was a big kind of, I don't know if complaint is the right word, but MDMA had an OIG official come on and he took questions about this fraud alert, at which I was kind of surprised but happy that he did that. And that was one of the big comments, MDMA is Medical Device Manufacturers Association, where someone said, look, people need to like touch our device and see how it's used. We might have a wet lab or dry lab set up at a speaker program. We can't really just, there's limitations over the internet or, in programs like we're all doing today, where they're really going to impact the device industry. And he appreciated that. And bottom line, this last bullet, he said, we're going to apply a facts and circumstances test. This is just guidance. We're ultimately going to look at the whether there's real value with the programs or not. So yeah, it's a great point, Dulce. We can go to the next slide. I'll just rattle off some things highlighted here. This is that suspect characteristics test. That's kind of the most infamous part of the alert, if you will. So things they're looking for: little or no substantive information presented. If alcohol is there, pharma has banned alcohol. Brent's going to talk about that at these meetings. Is the location conducive? Some of the complaints talked about meetings being held at sports bars and whatnot, places where they felt like it was really an entertainment venue. Are all the programs the same? Has there been a big time since FDA approval? Let's go to the next slide. Are attendees like frequent flyers, or does everyone there have a legitimate reason for being there? Is sales and marketing picking speakers? Is ROI being performed inappropriately? Like, hey, let's see how much we can get this person to speak, and then see if their sales went up because we're paying them to speak. Is fair market value appropriate, or are you bribing people based on the value or volume of referrals and purchases? Let's go to the next slide. So bottom line, just a couple of comments. Is OIG banning speaker programs? No, but be really careful with them. I think, let's go to the next slide. I think you need to, we would encourage, I think we covered this adequately. We can go to the next slide. I would encourage you to kind of run through and ask yourself some of these questions. Again, you all will have these slides, so I won't run through everything, but definitely a time to audit your speaker program and make sure you're not the next Novartis, because you got to be careful. This is 100% on the radar of the government, clearly. I think that's the end of our presentation. We can hand it back. I don't know, Dulce, if you have any parting comments. If not, I'll hand it back over to Mary.
No, I would just say it looks like we ran out of time. Didn't have time for a Q&A, but the audience members should feel free to email us with questions after the talk if we don't have managed to get to them today. And apologies for that. We had a lot of content to get through.
Great. Well, thanks, Mark and Dulce. And like they said, feel free for those people who did send in Q&As to contact them.